Welcome, everybody, and thank you for joining me this week on this edition of IPWatchdog Unleashed. My name is Quinn. I'm the founder and publisher of IPWatchdog.com. Happy to have you joining us again this week for this edition. We're going to talk about the PTAB. There's a lot going on at the PTAB right now, some of which you probably already are familiar with. It's been going on for several months with respect to discretionary denials, but most recently and more specifically this week, at least as of the recording of this, we have comments that are now closed in the latest Federal Register notice put out by the office to change the rules. We're going to talk about what the rule change would be, what the commenters had to say, and I'm glad to have Scott McKeown with us here this week. Scott's a good friend and someone we return to all the time whenever we have questions about the PTAB. Scott, thanks for being here.
Thanks for having me, Gene. There's 10,000 plus comments, so we better get started if we want to get through them all.
Were there really that many?
It was over 10,000.
So I heard that this is a couple days ago. There were over 700 individual commenters, right?
Correct.
And then they made, each of them made a lot of comments. So, well, let's take a step back before we go dive too deeply into it. Mm-hmm. But what is it that Director Squires is trying to do with this rules? Because the rules package is not terribly long, right? It's pretty short and pretty direct.
It is. I mean, I guess the answer depends on which side of the equation you are in the patent ecosystem, right? If you're
right, we could get down to that specifically here in a minute, but like just objectively, what if he were here? What would he say he's trying to do? And then I'll give you the opportunity to talk about, well,
Sure.
What does everybody else think he's trying to do?
I think the Patent Office would say, well, we call this the one and done rule package because we think, as a matter of fairness, that if you have a patent, it's granted, it's in litigation, it's upheld in litigation, or it's upheld in a patent re-examination, that should be it. You shouldn't be able to then, you being the next defendant or whomever, be able to come back to the Patent Office after either the Patent Office has made a determination or a court and challenge the patent again. That, in a nutshell, is what they're trying to accomplish with the rules, and there's various mechanisms proposed as to how they would get to that.
So that's something that I have always been supportive of, but from what I understand, anytime I've talked to people from the Patent Office about this, there are some Supreme Court cases that seem to suggest either directly or at least implicitly that everybody has a right to challenge when they have an issue, right? So there's been this thought that you couldn't necessarily say, well, Gene, you already challenged, so that's going to have implication for Scott not being able to challenge. Is that right? And is what the rules package trying to do something different?
I mean, the narrative that comes from the Patent Office and those that support the rule is always very general. Well, it's unfair to have multiple challenges, and that sort of resonates with most people. Yeah, second bite at the apple doesn't make sense. But what's happening in practice is you have entities that are in the litigation business. That is their business. In some cases, they're funded entities, and they're suing multiple people around the country, if not around the world, at different times. So if they're suing Apple in 2018 and Apple challenges it, and then they sue Microsoft in 2021 and Microsoft challenges the same patent, they're arguing, well, that's unfair, which, right, in litigation, that's how it works. Everybody gets their own defense. You can present prior art that's different from what Apple did if you're Microsoft years later. So the one and done is a little bit misleading. It's really about one litigation, right, and done. And now forever, this patent is gold plated. And if you look back at why we have the AIA in the first place, it's an alternative to litigation. It's not an alternative to the first litigation. And so that's where I think it's a significant overreach for the agency to propose this rule, which I think is pure legislation, to say, no, we think this is the way that the system should work, which in essence is what they're doing.
So we bled over into what, and I should, let me take another step back. I always ask you this when you're here, just so everybody knows, like where your perspective is. Tell us what your breakdown is between patent owner and petitioner at this point.
It varies, but I would say I'm probably petitioner more than I am defending patent owners, but it's not it's not incredibly lopsided. It's probably 60-40.
Yeah, and I know in the life
Petitioner.
sciences area in particular, you do more patentee stuff, right? And where people will even come to you and ask you to look at patents before they're even filed in some cases to see, like, well, what do you think about this?
Right. It's across the board. I mean, I will admit that I tend to be pro-petitioner, not because that's my business, just because I tend to see the worst of the worst actors out there, and I know how the system is being abused. And so I think a lot of times the conversation is, on the other side, it's this very one-dimensional. A lot of times it's an independent inventor that's never been a defendant. So they don't really understand the manipulation and the gamesmanship and the bad actors out there that are suing, right, small businesses and have them on the verge of going out of business and taking away research dollars and just really abusing the cost of litigation, which is why we have the AIA. And a lot of people, it becomes, well, that's not that big of a problem, but it is.
So, and I would say, from my perspective, as you know, I'm much more of a patent owner perspective. And I would almost answer it the same way you did, because I see a lot of the abuses that are out there. Mm-hmm. And I think just there's a lot of abuses on both ends, and maybe in the against patent owners, it may be, I think, even more because you have a small group of very well-heeled companies that just are never going to pay anything unless the Supreme Court says they have to pay something. At least that's what one particular fruit company filed at the ITC, that they were not going to pay unless the Supreme Court ordered them to pay. Mm-hmm. But then I also know on the other side, you have patent owners, like you say, that they'll get a patent and here's the title of the patent. You seem to be doing something similar to the title of the patent, and then they try and shake people down.
Right.
The frustrating thing from my perspective is that type of bad actor on the patent side, I think, was precisely why we had the PTAB to begin with. Mm-hmm. But too often it seems to me, and I'd like you to comment on this or any part of what I've said, but too often it seems like that abuser doesn't wind up having their patents challenged at the PTAB because, they only want $10,000, $20,000, $50,000 to go away. And I just think we fundamentally need to shake up the system. And I don't know whether the one and done, I like the one and done philosophically. I understand the problems, which we can get to in a minute, but I just think we need to grab the system by the ankles and shake it.
There's numerous things that could be done to bring more balance to the system, but that's something that, unfortunately, Congress has to do. And right, they can't even keep the doors open. I mean, that's how we've sort of gotten to this point. Not to get too political, but Congress just is dysfunctional, and they're so bogged down with keeping the doors open and budgets, and they can't get to all of these other issues. So now you have, the administrative state and the executive saying, well, if we can't get it done through Congress, even though right now the Republicans control both, we're going to have to find another way to do it. And that's why you're seeing proposals, which, we're talking about one in particular here. It's more legislative than it probably should be. And that's a consequence of dysfunction across the government.
Well, and it gets us, the one nice thing about it, though, is it does get us out of the governing by memo, which is what we have been doing up until now. And there is a process. I wonder whether people feel like this process, everybody knows what's going to happen on the back end. We'll see. Maybe there'll be changes. Maybe there'll be tweaks. I don't think there'll be wholesale changes or tweaks. No. But the problem here is, I think, with the legislation. And not necessarily, I don't think we should have created a PTAB, or I think it should have looked very differently if I could have created it. And I do think we need to have an error correction system, unlike some patent owners. I'm like, look, I'm an engineer. Mm-hmm. You never get everything right from the get-go. There has to be an error correction system.
Yeah.
But the big issue here is when you like it and it's on your side, it's great. And when it's against you, it's not so great, is that the director has discretion. So how do you say, and I'm not like saying, how do you say, Scott, what pointing your finger, but like, how do we wrap our heads around this? The director has statutory discretion to do really whatever the director wants with respect to instituting these cases. And then, but if you put it into a rule that goes too far, and because I'm not saying I disagree with the people who question whether or not this goes beyond and gets into the legislation making business, because there's an argument certainly there. But how do you square he can do what he wants with discretion?
Well, I mean, I think that's part of the struggle right now and why there's so many mandamus petitions pending at the federal circuit. The question is, well, really, is there that much discretion there where you can literally do anything you want? That doesn't seem like the correct answer. I think when Director Vidal was up in front of the House Judiciary, one of the questions from one of the House or committee members was, where's the word discretion in the statute? I don't even see it. And so, the problem I've always had with the exercise of discretion by the agency, I believe, there's certainly discretion in the statutes. You have, specifically enumerated 325D, other statutes of, you can consider the merits, but if it was raised before, right, you can deny it. But ultimately, the discretion needs to be grounded in the expertise of the agency. It can't be, well, we think, the agency, that it's better for the patent system if the Texas court handles this. That's not something the patent office should be deciding. That's something that Congress should be deciding, and that was just fintive. We're not even talking about what's going on now with statements such as, well, if your patent is older than 6 years, you have settled expectations. That just dropped out of the sky, right? That doesn't exist anywhere in patent law. You certainly can't make that argument in court. So how is it that an agency is legislating like that? And that's the disconnect as well. Yes, there's discretion there. It's certainly not unfettered discretion. And, how is it that the agency can do some of these things? And so, like I said, that's the mandamus challenges, and I'm sure soon to be APA suits and numerous other challenges.
So I'm going to push back a little bit on this discretion, because I do think going back to the statute is a fundamental flaw of the statute. And this one is entirely predictable, right? If you make a decision non-appealable, then what you're doing, whether you like it or not, is you're insulating the decision maker and telling the decision maker, well, you can go ahead and do whatever you want. This is not appealable. And the Federal Circuit has chipped away at that in a very modest way, right? Saying if you have a constitutional argument, we'll hear the constitutional argument. Mm-hmm. But they have been saying very consistently over the many years we've had this PTAB now, they're not going to second guess whether institution should have happened or whether it should have been denied. And I just, because we got into that period of time, and I don't know whether we're still there or not. I don't know that we have enough evidence, because Congress is totally dysfunctional. They don't seem to accomplish anything anymore. Right. But back before they got to the point where they were actually functional enough to do things that made no sense, right? You remember that? Right. And this goes both ways. This is not an indictment of Republicans, not an indictment of Democrats. It's, you love your congressperson and you hate Congress. I mean, that's the American way. Every poll says that throughout my entire life. Mm-hmm. But when you got into this period of time where it seemed like Congress was just abdicating their responsibility, and increasingly more and more of agency decision-making became non-appealable. And they became much more comfortable with letting agencies do things, and what affects us is the PTO. But it was an EPA thing, and it was global warming overtures going on here, and a lot of unpopular things that certain people in the government wanted to do, but they realized that, well, if we do that, then in tight districts, we might wind up losing. So let's just let the agencies do these things. Oh, and let's let them not be appealable or challengeable.
I mean, I sort of see it as, you look traditionally, you look at the conservative justices on the Supreme Court, their views on Chevron and the growth of the administrative state. It's always been, wait a minute, this is not how any of this is supposed to work. And in the first Trump administration, the memo came out, executive order rather, hey, agencies, stop governing by memo, right? You don't have all of this power. And I think there was a learning curve there of, well, on the one hand, we don't like that, but now we're at Trump 2.0. We didn't get as much accomplished as we did the last time. Maybe this is the way to do it. And we've got people out on the street saying, oh, no kings, because of all these changes that are coming from the executive through the orders. But the minute that the next administration comes in, it's Democrat, you better have a king to undo all of that.
That's what conservatives were saying when Obama was president, right? And Obama famously said, and I think this led us down a different path where Congress can do it. They've got a time limit to do. I forget what it was. And if they don't do it, then I'm just going to govern with my pen.
Right.
And it's like, wow, that was a shocking comment when he said it. But that's now the shoe's on the other foot. And that's why we get this. I think we get these snapback reactions.
Right. Obama certainly took on the executive order power. I would say, sort of utilize it, in more of the modern sense that it's become now. As now every time an administration comes in, Democrat or Republican, it's everything that last person did, we're going to undo it, and we're now going to take steps to make it even more difficult for them to fix it. And so. And this is not unique to the PTO, but, let's unravel as much as we can and make it so that when the next administration comes in, whether it's passing regulations, make it more difficult to roll back to where they were. And so that's where we are.
Right, and just to put a historical stamp on this, it's something that Director Iancu couldn't accomplish. He didn't get a major PTAB rules package through, and it's something that I don't even know that Director Vidal tried to do. She did some rule packages, but I don't think she tried to overhaul the PTAB. And so that's why you got into this governing by memo. The one thing Squires is trying to do to make it tougher, simply because it takes everything going smoothly, at least every second of 18 months to get a rules package across the finish line.
Yeah. Probably
much closer to 30 months. Because it's so easy to have things slowed up. And, there's certain times of the year things don't happen. And nothing happens in government from about the middle of December until about the beginning of February. There's recesses, there's elections, which resets everything, and now we have to worry about shutdowns, which closed the government for 7 or 8 weeks, and now unless they get a deal over the next few weeks, it's coming again, right? So getting a rules package is only going to take longer and longer and longer in the future, particularly when you have 700 plus people filing 10,000 plus comments.
Right.
I mean, slowing it down. I mean, just the number of comments, the government, the rules, if they're following the rules, and I don't suggest that they won't follow the rules here. You got to read every comment. You got to consider every comment. You got to respond to every comment. Now they can group these together and say, well, we got a dozen that said this, we got 100 that said that, but you still need to group them one, and you got to answer them too.
Yeah, and I think the last couple directors, especially Director Iancu and Vidal, coming in from private practice, I think it can be sort of just really surprising and sort of sobering as to, you're in the government now and this stuff just takes forever. And there's all these administrative hurdles. And the one package that Director Iancu was able to get through, relatively quickly was changing from BRI to Phillips. And the reason was, this is not a significant rule package. We don't need to go through all those hurdles. And so that's what they're using that playbook now on this one and done rule package, which is probably the poster child for significant rules. So, ultimately, I think that's where they're going to run into some real problems getting this across the finish line. It's a very significant rule package. When you have a rule package and your justification for the rules is, we think this was the intent of Congress, you are telegraphing to the world that you're legislating. And, just to get into some of the particular proposals, you have one proposal in this rule package, as I said, if the patent is upheld in the district court or, the PTO, then that's it. You don't get to come back to the patent office. That was an estoppel provision in inter partes reexamination, which was replaced by the AIA. The Congress specifically took that out. So it can't be more obvious that...
So that one is quite fragile then.
And it's, how can you say you're implementing the will of Congress when you're doing exact opposite of what they did when they put the statute together? So, In some ways, and it seems really strange to say this, but I don't take this rule package seriously. I think the Patent Office takes it seriously, and everyone else should be taking it seriously. But what I mean is, I just don't see how they can possibly get this across the finish line.
When you come and you say things that I don't like to hear, you have a scary high level of prediction, like your Karnak, right? I mean, I can't off the top of my head think of something that you predicted relating to the PTAB that wound up not actually happening.
I mean, I think this one, when you see, getting into some of the comments, you've got 14 or 16 former senators and House members commenting that one of them happened to draft the AIA saying, what is going on here? And they're sending separate letters to the Office of Management and Budget saying, are you guys looking at this, right? I mean, there's just so many wrenches that can be thrown into the gears here and have already been thrown into the gears. And we haven't even gotten to, if it's proposed as a final rule package, then the lawsuits start popping up. And so it's a long road, and the current administration is aware of that, which is why they've sort of started it so early and frankly are pushing it faster than maybe they even should have, with 30-day response periods, things like that. So do you think that that's why Senator Quinn and Senator Tillis sent their comments in, which the conclusion, if you haven't had a chance to read this, not you, I know you have, but others who are listening to this, their conclusion is that while they seem to like what this rule package is, they think it's very important for the office and the administration to get behind the Prevail Act. Well, see, that's the concern. And you'll see this in the comment from C4IP as well, which is, wait a minute, you guys are breaking IPR to the point where the Prevail Act is now moot, and we're trying to get, Coons and at least Coons, Tillis is sort of a lame duck, but right, he's playing the long game. C4IP is playing the long game. We want statutory changes. If you guys destroy this to the point where it's no longer viable, the Prevail Act is, what's the point? Right. And that's a serious concern from folks on more of the legislative end, and it should be. No one is going to see. I don't really think the Prevail Act was serious legislation to begin with, but regardless of my opinion, when you have these thousands of comments coming in, you've got politicians on both sides. Right now it becomes, this is a lot more than we thought, and now a lot more people are paying attention to it. And it's a patent issue, and most major politicians in D.C. really don't care about patents unless you can spin it like the AIA didn't pass because, hey, we need a patent review mechanism. We need this jobs bill. Which was just the greatest. And the Prevail Act is being sold as we need to fight China, because you can sell that to the American public. You can't go back and start talking to them about estoppel and cetera stipulations and patent lawsuits. So it's getting to the point, and the comments in particular, I think, are raising the profile. And some other things have been happening at the Patent Office with respect to Chinese entities that have annoyed China. So I think there's more of a spotlight starting to shift over to actually what's going on at the Patent Office, and that's just not going to be good for getting any of this across the finish line. Mm-hmm. So I do like fundamentally a one and done, because I do think that from a patent owner's perspective, if you don't have quiet title, you don't have anything. Now, I think if you have a patent that can just get challenged over and over and over again by different people, mm-hmm. when you bring enforcement, then you have no right at all. It's not a piece of property. Like if somebody trespasses on my property and they have to define the property lines because they're not as clear, and the deed is from the northeast, and they still have Mrs. Smith's oak tree down to the pile of rocks by the river northerly direction to a well that hasn't been there for 100 years, right? You got to say, okay, what does that all mean, right? And we have a hierarchy to understand real property, and then the judge decides, and now this is what the boundary means. Well, I don't then have to go and prove that all over again from scratch with the next person who wants to trespass on my property. And so that's fundamentally where I come at with respect to these repeat challenges. And it's not a single repeat challenge. It's a different challenger challenging the same claim over and over again and bringing up their own arguments, maybe even to some extent, maybe different art,
But that, I think, has to stop. Now, the way I've written in the past and have said about it, I don't see anybody gravitating to this. We have a solution in place. We know how to extinguish people's claims. We do it every day of the week in bankruptcy court. Come one, come all. If it matters to you, show up. And if it doesn't matter to you, don't show up. But we're going to settle this at the end of this proceeding. Mm-hmm. It would seem to me to be, we ought to be able to do that in this scenario. Now, I think what we've talked about in the past is a lot of these patents, well, I didn't know that this could even be interpreted to be used against me.
Right.
I'm fine to have a carve out and say, look, if that's your argument and you can demonstrate it and a judge can say, yeah, no, nobody would have reasonably thought you should have been provoked by the notice that went out, then fine. I mean, I think we as adults can handle that. We already do handle that kind of stuff with the notice. Did you get notice or did you not get notice? And I think there's a path forward here, but I just feel like too often both sides wind up trying to pound a round peg into a square hole.
Well, that's the problem, is the lack of notice, right? And the arguments made, or at least the comparisons made, well, the EPO has oppositions, right? And companies monitor the patents of their competitors, and sort of in a business-like, due diligence fashion, when one comes out that they think is improvidently granted, they file the opposition, and everything works fine there. But they don't have the litigation that we do. They don't have litigation as a business. They don't have the funding the way that we do, and they don't have patent owners that, invented X, now arguing in court that, well, no, my claims actually cover Y. And reading them, you may have never understood my theory because it's a little bit out there. And so, this idea of having sort of an incontestability period like you would in trademark, it's just, I don't think it's feasible. I mean, are we going to go to patent owners and say, look, you've got a patent, you're going to sue, party X, sue everybody right now so that everybody can get in the room and, we can have one filing or one defense? That doesn't happen. And so it's the differences in our system, and it's the way that our litigation businesses frankly run that is the reason why we need to have the mechanism that we have, and frankly we have had since the 80s, right? You can file a re-examination whenever you want, after expiration, whenever. The difference here, of course, is that it's fast, it's effective, and it makes a meaningful difference in the business of litigation, and so that's why it's getting this much attention.
So just as you were sitting there answering that, I was just going through my head and saying, all of these things are fixable. We could, but that would presuppose we would have a Congress that would want to do it.
Right.
And we can't even get simple things passed in this Congress. They just won't agree on anything. Just because the other side wants it doesn't mean it's something you should object to. But that's the world we live in right now. And so getting my head around the changes that would need to happen, and I think everything that you just raised is solvable, but it would have to require like a 1952 Act kind of level, going through, changing litigation, considering even the British rule, maybe with some caveats, like if it was loser pays if their position was unreasonable. Okay, well, what does that mean? That we could never even solve that piece of this puzzle, right? Let alone all the other complicated mess about, notice and how could you have possibly known, like some of the software patents that were issued not technically pre-AIA, but pre-generative AIA. People weren't thinking about this generative AI. Most inventors weren't when they were getting their software patents, but there's probably are a number of those that read on truly remarkable AI innovations.
Well, I mean, if you take PARA, the Patent Eligibility, Restoration Act, that would seem like it's something that is relatively easy to do, right? We have this morass of 101 case law. Everybody agrees it doesn't make sense, whether it's, former Federal Circuit judges, all the way down to inventors. The Patent Office has issued their own guidance to try to make it, more coherent. And PARA's been, I don't know how long it's been out there, several years. It seems like a common sense solution of, let's just throw out all the case law. And if you're not in these enumerated categories, you're good. That would seem like the most straightforward fix in the world. And the reason that we don't have that fix is because the extremists on each side, they want the perfect version from their point of view, and there's no compromise, right? It's let's let the perfect be the enemy of the good. And you see it with these rules, right? These rules are overwhelmingly patent owner friendly. And you have patent owners filing thousands of comments, sending links to AI engines to submit these comments, and they're asking for more. And they're slowing down the process with these comments and shooting themselves in the foot in the process. That's the world we live in now. It's the Bloods and the Crips, the red and the blue, and right, your objective is to kill the other side, not to work with them.
The pro-inventor side has stood in the way of any meaningful pro-inventor, pro-patent owner change, at least the last 10 years, right? I mean, certainly going back to Director Yanku was there, and then you had all these people asking for all kinds of unreasonable stuff, and you had the roundtables. This was, I think, even before COVID. They started with the roundtables on 101, and the inventors weren't getting enough. And then even after that, now with the latest version, you have some of the inventors running around saying, "Oh, this makes artificial intelligence patent ineligible." It's like, no, it doesn't. It says if it can only be done on a computer, then it's eligible. And I don't know, we're not at the point where these AIs are synthetic, organic androids. I mean, so of course, I almost don't know what to do, because it does feel like when you go and you talk about these things, it's like, well, one side says, well, I want X right up until you're willing to give me X. Then I kind of reevaluate, well, that X probably wasn't a really good idea if you're willing to give it to me, There's that. And then there's I'm only going to take 100% of what I want, and if you don't give me 100%, I'm not going to do anything. And the problem is this is like a kaleidoscope, and the different actors have different views. Some want 100%, some like what they want until you like it, in which case then it can't be good. And then the reality is none of this does anything other than alienate voters and donors from the congressional standpoint.
And so you've had Tillis and Coons that have been driving this for years now. Tillis is on his way out. He's somewhat of a pariah in his own party, so he's politically damaged. Is there enough juice there now to get Pera across the finish line? He's sort of stated that that's his goal before he's gone. They may have waited too long. And you still hear of, well, we're revising it, and the minute that revised bill comes out, someone's going to call it garbage, and we're just going to continue chasing our tail.
Well, that's the other thing, too, is all of this has happened is what you see is the people who have the most ability to affect these things, because they have large teams of lobbyists. They employ hundreds of thousands of Americans each, some of them maybe even 1 million or more Americans. Those folks don't get involved until the end.
Yeah.
Right, and then once it starts to get real, now they come in and they have the juice to pull something back from seeming inevitable. Not that any of this has ever gotten to the point where it seemed inevitable.
Well, and we're heading into midterms in 2026. Is there going to be a big appetite for Pera with Tillis on his way out and somewhat radioactive in his own party? That we've spent years and countless hearings and 50, 60 witnesses, and we're no closer now than we were before. And I think after Tillis is gone, it's almost back to the drawing board. Right. So, I mean, just using Pera as an example of why legislative fixes are, they're almost just fantasy at this point.
Well, I would quibble, but this is a distinction without a difference. I think we are closer than we have been, but that's only to say that, well, if you're in New Jersey, you're closer to California than you are when you're in London.
Yeah.
It's not to say we are, by any stretch of the imagination, close.
I would agree that 2026 has to be the year, or like I said, we're probably starting over.
Right. And that's what it feels like. We're starting over and over with so many of these things, which is, so let's go back to these rules again. And I've said now this will be at least the third time. I am fundamentally in favor of a one and done. I don't know that this one and done is how I would have done it. And, they were going to hopefully take these comments to heart and probably make some changes. And if they don't make changes, I would think that would not bode well for any of the litigation that comes out next. But is there a group of comments or like more people raise this as an issue or raise that as an issue? What are the thises and that's?
The pro comments, at least the ones that I've read, are, typically very devoid of detail. It's, well, I like this. This is the way it should work. It's fair. By the way, you should go a lot further. It's a lot of that. And the comments against it are all pretty consistent of, you just don't have the power to do this, right? This is legislative. This is a major rules package. This should be in front of the Office of Information and Regulatory Affairs in Washington, D.C. Squires sat in front of Congress and stated he would work with Congress to make sure that the AIA remained viable, yet this rule package was issued where the agency has taken the position that they're implementing the intent of Congress. There wasn't a single meeting. So, it's that's the back and forth. And like I said, I think the administrative obstacles and office and management and budget details, they may be coming back to haunt the agency on this effort, because now there's a lot of attention on not only this rule package, but what's been going on with the PTAB in general and how the director's been denying, I don't know how many hundreds of petitions, where that never happened before.
So let's start with that last point. Is there a theme with respect to the denials or any clumps? You have some more like this, some like that. Is there any themes emerging?
I mean, the general themes are, if you're in Texas or you're in the ITC, you're going to get an early trial date, and you're probably not getting instituted, regardless of any stipulation you might file. And if you have a patent that's older than 6 years that you're challenging, you're probably not getting instituted because of this settled expectation. So that takes out, a huge swath of challenges that came to the agency, because it is an alternative to litigation. If you are in Texas, right, you want to go to the patent office, and because the litigation is disproportionately in the tech space and a lot of times funded, the patents will be older because nobody's investing for 1 year of damages. They want 6+ years of damages. So, frankly, the point of a lot of these changes is to sabotage the PTAB as much as possible. It's my jaded view, but you can't really rationalize it any other way, as the current administration, and I'm talking about the agency, not necessarily the Trump administration, doesn't like the PTAB. Howard Lutnick doesn't like the PTAB, and so some of these policies change right from week to week. There's something new right every week that comes out, some new memo or announcement or presidential decision. And, it's pretty clear that it's just, it's about, like I said, undermining the AIA as much as possible. And if you don't like the AIA, it's great. But again, we get back into, is this the way our government should run, right? Do you want political appointees basically deciding what the law should be? If your side's in office, the answer is yes. And in a couple of years, it will be no. Yeah. I don't really like this king's idea, Yeah.
I also think that a lot of what's going on here now, and I don't know why this is, but I think increasingly over time, government in general, but more specifically, this is an executive, and it's not a Republican or a Democrat, it's just an executive. Whoever's running the executive, they don't want to explain why they're doing what they're doing. And I think it has to do with the fact that now, if you don't like something that the executive branch is doing, you sue. Mm-hmm. You sue in the court that hates that party the most, right, and somehow try and get judges. And they always seem to get judges that were appointed by the other party. And right, how that happens with such almost near 100% consistency, I can't tell you, but I have my suspicions that we're not really dealing with a wheel assignment in a lot of these districts. And I also understand that may not be super fair, because a lot of these districts do lean one way or another, and it's not going to probably be too uncommon to have way more people appointed by Democrats in Maryland than you would have in Wyoming, for example, yeah, right? But there's some stuff that makes me want to scratch my head and say, I don't really know what's going on there. But I think they don't want to explain what they're doing because they're afraid of being challenged, whereas what I would do is the exact opposite. And in this case, you have the benefit of the statute, I do think it gives discretion. I may not use that word, but I think the Supreme Court in oil states recognize that there's discretion here. And I would wrap myself in this discretion. And if I were running the patent office, which we all know has got zero chance, that will never happen. What I would say is that, look, I want to go back to what really was intended. And what was intended, what was sold to Congress, was a PTAB that was going to handle plus or minus about 450 to 500 cases a year. And we've come in most years 3 to 4 times that number, not every year, but most years it's been at least 3x that number, if not more. Like, so what happened? Why did we get this wrong? And I would say I think it's because we have an overactive PTAB. You know, when you are a hammer, the world looks like a nail. And I don't think you got to go into the nefarious to say, judges, you're hired to because we have a problem with bad patents. So then what we're going to do is, well, they're going to see a whole bunch of patents that are bad. I mean, it's just human nature. And I think if you attack and say, yes, I am trying to change the way the PTAB operates and wrap yourself around it, but then pick and say, because of this, because of that, and the other one that they don't talk about enough, agency resources. You know, we in the outside, us and our clients have limited resources. Mm-hmm. Well, as it turns out, we're almost $39 trillion in debt. The federal government's got limited resources, whether we want to acknowledge it or not. So they constantly have these patents like, well, Microsoft is challenging it this week. Apple's challenging it last week. Samsung challenges it at the beginning of next month. You know, that can't be. The agency can't do and redo and redo and redo something that is also supposed to be a property right. I know it's a personal property right. The Supreme Court used to say patents were akin to real estate and, you know, patents and land, but it's still a personal property right. And I think there's enough levers that you could point to and say, yes, embrace yourself. Wrap yourself around this. I'm using my discretion. If you don't think I have it, let's have that conversation. Because I think just throwing it out there like this leads to people not understanding the vacuum always leads to a conspiracy theory. Because I'm not sure I could push back too hard on what you said is that it fundamentally seems like they're trying to get rid of the PTAB or neuter the PTAB, right? I don't know how else you could look at what's going on and not come to that conclusion. Now, from my perspective, I think that makes sense. Now, from your perspective, it doesn't make sense. But I think we need to crystallize these issues a little bit more.
I think when people are of the viewpoint that the PTAB is doing too much or they're going out of their way to cancel patents, it's always this fundamental disconnect of, well, I believe that because I live in the litigation world, and patents don't die from obviousness in litigation, and now they are, therefore something is unfair. And obviously there's different standards between the court and the agency, and that's argued as unfair, but I mean, ultimately, the question is different. Validity in the district court is, well, we're an Article III court. We're looking at what this expert agency did. And if we are going to overturn what they did, just from a separation of powers perspective, it needs to be really clear and convincing that there was a mistake. Mm-hmm. And so that's validity. And patentability is, I'm going back to the patent office, to go back to your tree and well and property line analogy is, well, the tree moved since you looked at it last, The facts are different. And I'm not asking you to defer to your own decision, You can decide if you made a mistake. And you have the expertise, so I'm giving you the prior art, and you need to decide, almost retrospectively, had I had this prior art in my hand when I first issued this patent, would I have issued it? And that's a very different question. And so, of course, there's very different outcomes.
But let's go down that path, because I'm not sure I disagree with you, And what I think when I think one and done, and who knows what this rule package is ultimately going to be if it ever winds up. I'm sure it will go final, but if it ever winds up seeing the light of day, who knows what it'll actually say. But I don't have a problem with going and saying, look, if the examiner had this, they would have come up with a different answer. What I have a problem with is, Apple coming and saying that, and then Apple winning or losing. It would, if they won, it wouldn't be a problem. So Apple loses, the patent owner wins. Then next month, Microsoft comes and says, oh, well, if you didn't have this, and it's this over and over and over again thing. I just think at some point in time, if this is really a property right, that can't happen. And if it's not a property right, then why are we only giving these rights for 20 years? I mean, because it seems to me that, and I know with a lot of innovations, that's a long term. In the software stuff that I used to do when I was practicing, 20 years was useless. It was obsolete way before that. But if it really is just this like license or franchise, and the Supreme Court didn't misspeak, they were just acknowledging reality, then it seems to me that we got to look at it differently on that side.
But the way you described it is the way it's always described, which is, well, Apple filed this, and then this other company came in, this other company came in, and it's sort of presented as like gang tackling.
Right.
You can't do that. The way what actually happens is like the example I gave earlier is, Apple gets sued in 2018, this other company gets sued 4 or 5 years later.
Right. That was what I had in my head. And
right.
It wasn't. So let's take a step back. Describe for the audience, if you will, briefly, this idea of gang tackling, and that hasn't been allowed for some time.
So, for example, if there's, let's say I have 3 or 4 lawsuits pending as patent owner, I see a challenge come in from Apple, I file my response, I make good arguments, maybe I identify a hole in their case. 2 weeks, a month later, right, the other company says, aha, now I got you, right? I can plug that hole.
Right.
That's sort of using the process as a roadmap, gang tackling, right? Unfair. So that's not allowed, and that wouldn't be allowed in the district court either.
Right.
But
okay, but what I had in my head was not that, which has been solved. I think Yanku was the one who solved that, or at least started the solve for that, right? What I have in my head is what we were describing, like I am a patent owner, then I sue Apple. Apple can challenge. Then I'm a patent owner, and I have independently sued Samsung, maybe often in different courts anymore since TC Heartland, right? And then I also am suing Microsoft, maybe in yet a third different court. But each of them has the ability to then go to the PTAB in their time, within the time limits that are allowed within those decisions that I've made as a patent owner to challenge the patent. Whereas I don't think the way that patent litigation had grown up in America, at least what I was familiar with, that would be, district courts wouldn't give that any time of day.
But that is the way the district courts work, right? If you sue Apple in 2018, they get their defense, and then later on, Microsoft gets their defense 4 years later. They're going to read that earlier record. Right. They're going to decide what, they've got better art or how they might, come to a slightly different argument, and that's the way litigation works.
Right, it is. But the district courts, this with the second and subsequent ones, are, in my experience, extremely, maybe not today, but back when we were growing up in the industry, we're extremely skeptical.
This is the same, but the outcome favors patent owners most of the time, so we don't complain about that one. But at the PTAB, right, there's judges that have the expertise, technical expertise, and they understand obviousness very well. It's I've said before, it's an obviousness court. And so the outcomes are very different. So now we attack the process when it's not really the process. Right. Setting aside all the legal infirmities with the proposal, here's the huge problem. If I'm representing a patent owner under this, and they're about to go out on this litigation campaign, and we're trying to figure out who we're going to sue first, I'm going to pick out the weakest company that has the worst attorneys. I'm going to sue them. I'm not settling. I'm going to get some kind of summary determination, or I'm going to get some kind of decision on validity, and then I'm going after the big companies. And that's how it's going to play out because, right, that's just how you would play it.
Well, but that also is what happened. I don't know about today, but that was what was going on back in the day because you didn't. But
to an extent,
you didn't do it for that reason necessarily. What you did is you did it for I'm not going to go after Google or Apple or Microsoft first because that's a hard case. They're going to fight forever, and I don't want to go after the weakest link in the industry. So you go after somebody that's in the top of the bottom third, so that you can get a
build your war
chest, and then everybody who's lower than them.
But there are people, on the spectrum that I wouldn't have bothered with before, especially if I'm funded, right? I need to get a return on my investment. Well, now it makes sense to go after these smaller companies, which is that how we want, these rules to impact, American companies is now the weakest and the smallest are the most vulnerable to patent suits? It just doesn't.
See, that's a longer conversation for another day, but it's one that does bug me.
Yeah.
Because in the way I hear it come up, I've heard it come up in the SEP space, where the small companies say, I can't take that license because, one, your math is wrong. If I agreed to that, I would not make any money. But aside from your math being wrong, the biggest players in the industry have told you no. So if I tell you yes, then I'm going to be anti-competitive compared to those people who you can't force to pay you anyway.
Right.
So there is a big issue here with the smaller companies, which still, for better or for worse in America, that's what drives the economy.
Well, and a lot of argument about the PTAB too is, well, small companies aren't using the PTAB. Well, that's correct to an extent because they're the ones paying the $20,000, $30,000
Right.
settlements. And now that there's no PTAB to worry about or these small companies banding together, that $20,000, $30,000 demand just increased to $150,000, $200,000. And, right, you don't see that expressed in the filings. And that's the kind of stuff you would expect to be studied by Congress and Office of Management and Budget, and the reason why we can't shortcut these processes.
So listening to you, I'm even more convinced that what we need is we need to take this 15 years or so of experience and I think throw it all away, not the experience part, not the knowledge part, and start over. So, okay, what do we want to achieve? What did we want to achieve? And how do we go about doing that? Because I'm afraid that, even if and this was one of the things that would make the legislating extremely difficult. If we want to change this line, this item, there'll be people saying no because, but change this instead. And I think you almost need to throw it all away and start fresh, because I do think there's a pony in here somewhere. And the one thing that just jumped in my mind when you said that, if there really are a lot of these small companies, and I have no reason to doubt that because I see it too, they get shook down for extortionary settlements. There has to be some kind of a way where the director could, you can have a director ordered reexamination.
Mm-hmm.
I mean, there needs to be some way to solve that problem, because that was the problem we were trying to solve. We were trying to get rid of the patent trolls. Whatever your definition of patent troll was, whoever in your mind was the bad actor, whoever was the ogre under the bridge, that was the person we were trying to get rid of, and that is the person who we didn't touch.
But we've had, re-examination was the first iteration of all of these ideas. Then we went to inter-parties re-exam. Then we went to the AIA. Now we're going back to a system that we knew didn't work 20, 30 years ago, that took too long. And so that's not really a solution for any of these companies either. And again, like we discussed, you have to get people in a room, sit down and talk about solutions, when on one side it's, well, the PTAB needs to go away, right? It's the extremists are going to be in the room, and you get nowhere. So it's just
well, you don't get anywhere. I mean, and I've tried to explain this to people. The PTAB is not going anywhere. It's just not. I mean, I think that over the last 9 months, 10 months, actually, well, no, now it's December, so over the last 11 months since the Trump administration, they have been trying to neuter the PTAB to the greatest extent possible. Still cases get instituted.
Yeah,
I'm sure you're getting cases that are. I think it's harder probably, and there's a premium put on better representation, and by better I mean people who have a lot of experience and know the technology. So it's not, even today, it's not going away.
No, I mean, there's a lot more, obviously, that has to go into the thought process with discretionary hurdles, but, there's still going to be 102 art out there that shows that, these patents were mistaken regardless of their age, and, there will still be filings, but, certainly there will be less filings, and people are now going back to the older systems that we know don't work, where Congress decided that we needed a new system because that system didn't work, and the reason being we've got, policy being decided by the agency, which is outside of their expertise.
So let me ask you this: are we starting to get any kind of development in the body of precedent on denials that tells us a little bit more about what it means to be well-settled expectations and the whole 6 years. Because it would seem to me that if I had somebody come, and I don't know that this happens because this is probably more the extortion people, and they wind up not being at the PTAB because it's cheaper to pay them $20,000 to go away. But is this like if somebody came and said, look, I could never have realized that this was going to be used against me because, it's just unreasonable. And the extreme that we can kick around very quickly is the claims really don't read on what we do. The title sounds exactly like what we do. Mm-hmm. Maybe the specification has paragraphs in it that are exactly what we're in the industry we're in, but that's not what the claims. I would not have known to challenge this. Has there been any?
There were a few cases early on, and this was not an actual case, but just to give an example, right? Well, the patent owner previously sued boat companies for power supplies in boats, and now, right, I'm a laptop company, and they're coming after me where, I couldn't have predicted that. Maybe not the best example, but, arguments that, well, this was in a very different market to mine, and now, you should take that into consideration. The problem is now, like I said, this has been changing almost every month. We don't get any feedback. You just get a thumbs up or thumbs down, so you don't know.
Yeah,
and
that goes back to my issue of them not explaining on any level. I don't think government explains what they're doing,
and it hurts patent owners as well when you say, "Yeah, we think one of these claims is likely vulnerable, therefore we're going to proceed, and we're not going to give you any technical feedback at all. You can just go in blindly and start arguing." But they've decided that, well, less detail is better because more detail gets us into all of these lawsuits, and giving people things to argue about due process and separation of powers. If we truly believe that we can just say no, then we're just going to say no.
So what if Congress just changed this and made it appealable?
I don't think that's a solution either.
Because the reason I raise that at this point in our conversation is simply because if it is appealable, and it would seem to me that the Federal Circuit would say, if you don't explain why you did it, I can't know what you did and why you did it and go back and tell me why so I can review it.
The problem with appeal is then, you want this to be a fast process, and you can't throw that kind of appeal in there because everybody would appeal. And then they would argue in the district court, well, we're going to be up on appeal for at least a year. You're not going to stay this case, are you? It's going to take another 18 months after that. So we can't have that, and I think the reason that is in the statute is the same reason it was in the re-exam statute is we just can't have this kind of interlocutory appeal going on and expect these things to actually get done in time to matter. And, since the AIA started, we at least now have director review, so there is at least some review above the panel that, if somebody was really playing fast and loose with the facts, presumably the director would step in and fix it. So that seems to be the best compromise from my perspective.
I don't know. It just feels hopeless. Without discussing the merits of this particular rule or the philosophy or the goal, I think the goal behind it is laudable. But I am extremely disturbed by the ping pong effect or the tennis effect between administrations. And sometimes it's not even between administrations. We saw, like during the Obama era, what happened at the Patent Office during Obama's first term compared to his second term. It might as well have been a Republican president from our perspective, right? It just totally changed. So even within parties, even with the same president, things can change dramatically over time. And that's no way to govern in this, because that's the whole point of having a national patent law, right? That's the whole point of like having every attorney will understand who's gone to law school. That's why we have national products liability laws, right, that are consistent across the states, because you can't sell something in New Jersey and then have a different set of laws and rules and standards apply in Arizona, right? You just can't have an interstate commerce system like that. And that was the whole point of the Federal Circuit, was because we can't have 13 different regions or 12 different regions deciding this. We want a 13th region, and we'll call it the Federal Circuit. And we have gotten so far away from some of these very fundamental legal principles, and it's just a ping pong game. My team's in power, and this is what we want to do. And
we talked about Congress being dysfunctional. I guess the silver lining of that is you can see things coming a mile away. They take years and years, and I think if you're an American business, right, you don't want the law changing all the time. You need to budget for these things.
Right.
And now we have companies that are needing to budget, a significant amount of money more over what they budgeted in 2025 for 2026, because the expectation and all of the data points so far are litigation is increasing, more funding is coming, and the window is open, and here we go.
Yeah, and I don't know whether you've heard this yet, but it's only a matter of time before we start hearing this. The people on the periphery say, oh, well, you're just saying this because you're a lawyer and it's going to take away business from you. And I've never seen a statute or a regulation take business away from a lawyer. They become full employment acts.
Well, uncertainty in the law generally is a boon to
right
law firms. So it's really the stakeholders, the patent owners, the research institutions, and American workers and engineers that get impacted by these things.
Yeah. Well, I wish we had a more happy, but
other than that, Merry Christmas and Happy New Year.
Happy New Year. Things are gonna get better. They can't get any worse, right? Don't say that, because every time I say that, things always seem to find a way.
It's an interesting time to be alive, I guess.
Yeah. Well, thanks for being here, Scott. I really appreciate it.
My pleasure, as always.